Hello, this is State Representative Peter Breen coming to you from downtown Chicago, the James R. Thompson Center. You may have seen in the big flurry of activity about SB 1, the Democrat Education Funding Plan, that a letter was sent by Leader Jim Durkin and Leader Bill Brady to the Attorney General asking for clarification about the effective date of SB 1. And this was something that was a little bit of a technical issue, but it's something I think needs to be explained from a lawyer's perspective. The problem is if SB 1 is not immediately effective, it would be effective possibly next year, June 1st of 2018. And if that's the case, then this school funding bill that's allegedly trying to fund schools for this year wouldn't actually take effect until after the school year ends. So pretty much defeating the purpose of this agitation by the Democrats to override the veto. So I looked at the letter, it's on CapFax, that was sent by the leaders to the Attorney General. And I said, the test here is not, is the argument that the effective date may be a year out, is that the winning argument? I'm not sure. But if there's reasonable doubt, if there's any real significant doubt that the effective date is not immediate, we have real issues. So just very quickly, I looked at it, did a little bit of research, and when you take that look of when is a bill passed, the Constitution dictates that the effective date of passage for any bills after May 31st, you go a year out. And so it's got to have been passed before May 31st or before. So when was SB 1 passed? The passage as it's defined in our Effective Date of Laws Act is, it says, quote, for purposes of determining the effective date of laws, a bill is passed at the time of its final legislative action prior to presentation to the governor pursuant to paragraph A of section 9 of Article 4 of the Constitution. So what does that mean? It's passed at the time of its final legislative action prior to presentation to the governor. Here's the problem. So the Senate concurred. They took a vote on May 31st. But that same day, a Democratic senator put a hold on it, put a motion to reconsider on it. And they were being cute. They wanted to hold the bill to leave it to allow more time to pass so that we would get really close to the beginning of school to try to increase pressure on the governor to sign the bill and on the Republicans to support it if there was need for an override. Well, so what does a motion to reconsider do? I did a little research. The case I found was Ceresa versus City of Peru, which is out of the appellate court in the 3rd District. This doesn't happen often, but that case very specifically said that, at least according to Illinois case law, in prior cases, the making of the motion was such that when it was made, the underlying action that the motion was reconsidering prevented the underlying action from having any legal effect. And so if the motion to reconsider literally prevents it from having any legal effect, well, then you can't very well say the bill was passed on May 31st. So take it a step further. When we put a motion to reconsider on something, you wouldn't think of sending a bill to the governor in that state because it's not been passed. It's not ready for his action. So the final legislative action in that argument would be lift the motion to reconsider. Now, as well, I went and looked at the Senate rules, and the Senate rules deal very specifically with reconsideration. And what you see in the Senate rules is, under their Senate Rule 7-15 sub D, when a motion to reconsider is made within the time prescribed, the Secretary shall not allow the bill or other subject matter of the motion to pass out of the possession of the Senate until after the motion has been decided or withdrawn. So in other words, it cannot pass out of the Senate. So they're using the word passage, which makes you suspicious. As well, when you look at the Senate rules on reconsideration and under Part A, when that motion to reconsider is made during the last 3 scheduled days of regular session, any member of the Senate may move that the vote on the reconsideration be taken immediately. So even within the rules, there's this recognition that those last 3 days are very urgent. And so if someone puts a motion to reconsider right at the end, it needs to be dealt with immediately. That would tend to indicate, at least if you're looking at the internal logic of the Senate rules, that a motion to reconsider needs to be dealt with prior to the end of regular session, prior to that May 31st date. So looking at all of these things together, now you've got that. And one final point, you go on the Illinois General Assembly website. There it says the Senate concurred on May 31st, but it doesn't actually say that the bill passed both houses till July 31st. So, all of that together, here's the thing. I'm not opining as to whether that's the right legal interpretation or the wrong one, but I just laid out a case that I would be willing to put in front of a judge if I were representing a client, and I could do it. They call it the red face test. In other words, can you make the argument without blushing because you're so embarrassed at how outrageous it would be? This argument actually has some merit, makes some sense. It's in the hands of the Attorney General. The problem is this. Naturally, folks are a little suspicious on the Republican side of the Attorney General only because her father is the Speaker of the House, who we're presuming helped to conceive this strategy to delay the bill to increase pressure on the governor and the Republicans. So unless there is, that the Attorney General finds a case from the Illinois Supreme Court that is right on point, that really puts this issue to bed, we probably have a place where we're going to have some real doubt about the effective date of SB 1. This level of doubt, you can't proceed in good faith on education funding where you've got $6 billion at stake, you've got schools opening or not opening. Where does that leave us? If that's the case, you've only got two options. One, you allow the governor's amendatory veto to come to the floor of the Senate and then to the House. Take it up honestly, debate it, and either accept it or reject it. If you don't take up the governor's amendatory veto, you have only one other option, and that is we start over. You start with a new bill, and you properly take account of the priorities of both parties. You don't do a bailout for Chicago, but you don't have to stick it to them either. We can figure out a way, and I know that there is a supermajority, bipartisan supermajority of the House and the Senate that's in favor of education reform for this state. And so I hope that, again, if the Democrats won't take up the governor's amendatory veto, that we work together and actually come up with a plan that both sides are comfortable with and that the people of Illinois can be proud of, instead of yet another legislative measure that's forced down our throats or done through legislative extortion, as has been done so recently, so frequently recently. Thanks so much, and I hope this has been helpful in terms of explaining this very unique point of law that really, it's neat that our non-lawyer governor, he had said, this is wrong. They're not supposed to hold the bill and not send it to me. And it turns out it may be that our two lawyer leaders, the two Democrat lawyer leaders, House Speaker Michael Madigan, Senate President John Cullerton, they may have actually messed up and been too cute in terms of trying to play political games. But again, we're going to see with the Attorney General's opinion, which we hope would come soon. Again, if you don't see a binding Illinois Supreme Court precedent in that Attorney General opinion, you probably have too much doubt here to be able to proceed with an override of SB 1. Thanks so much, and this is again Representative Peter Breen.